Thank you so much for joining us. Tonight is another opportunity to have this interaction with you. This program is proudly sponsored by Citilaw Solicitors. Citilaw Solicitors is where all your legal needs can be met. Obviously, for the past few weeks, we've been doing lots of topics under different areas of law, because for Citilaw Solicitors, we want to ensure that people migration needs are met. Those who are having accidents at work are able to claim the right compensation that they deserve. Those having family law problems, being a difficulty of having contact with their children or getting the right financial order that they deserve. Those who may have problems running their businesses and need a lawyer to bring an input to ensure that they have right system in place. So Citilaw Solicitors is able to provide all these services to you. And tonight we are going to discuss a very unique area of law under the family law. It's a very sensitive area, but obviously I am giving this as an educative program. It's very educational. So pastors who are watching me tonight, pardon me, but obviously some of you still come and see us. So we need to give this advice because there's going to be immense changes in the law. There's going to be immense changes under the family law. And tonight is an opportunity for people to get thumbs up, to be able to know what is going to happen on the 6th of April. So we've chosen tonight as a very special day, obviously, to discuss this area of law, which is the changes that are coming into force, which is the new divorce laws coming into force on the 6th of April 2022. So I'm going to do 3 things. I'm first going to look at the old law under the old divorce laws, and then look at the new laws that are coming into place. And obviously, those online portal changes that are also going to take place. And I will look at a very unique case law, which is the case of R versus R, where obviously decree absolute obtained by forgery can be set aside. So tonight I'm going to be very, very legalistic, and I'm obviously going to take my time because I know audience are watching me, and therefore I'm going to take my time to make it very simplistic for viewers to understand where I'm going with this topic tonight. So if you are watching me tonight, I need this favor from you. Ask me, what favor do I need from you? I need a favor that you share my videos to everyone on your contact, because people need this free advice. And I'm sure that you might not need this advice tonight, but someone somewhere needs this advice. And it's you that can help us to propagate this message and give this free advice to the public. This is part of our corporate social responsibility to the public. And that's why we do this free of charge. So for those of you who have joined us for the first time, we do this program on Tuesdays in English and on Thursdays with MC Chaka in Twi language. So tonight, as I've said earlier, we have discussed numerous areas of law in the past few weeks. We've had immigration, we had employment law. We've looked at how people can challenge their return to the offices or even get obviously flexible working at the workplace if they have kids or if they have disabled person in the house. We've looked at all these areas. And tonight we are looking at family law. And I know that this topic is quite sensitive. But obviously, on the 6th of April, there is going to be immense change in the law, the matrimonial law. the divorce law. And that's why I am here tonight. Because some people might have their applications in the portal. Some people may be thinking of making applications. And a lot of people are going to be caught with the fact that they are not aware that the grounds for making these applications are going to change on the 6th of April. And that's why I want you to share this video so that I can have the opportunity to interact with immense audience who are going to benefit from this program that I'm going to do tonight. So you watching me tonight, please share this video. I'm going to go for a short commercial break, obviously, to let you know all the stuff that Citilaw Solicitors does, areas of laws that we cover. And then when I come back, I will just jump straight into the topic that I'm going to discuss with you tonight, wherein I will look at the new divorce laws coming into place. After I have obviously taken viewers through the old law, or the grounds, or the facts that need to establish under the old law, and the changes that are coming into force under the new law. And obviously, for those of you who could be threatened by your divorce decree absolute being set aside on limited grounds, you probably have to watch me tonight and share my video. So viewers, if you have joined me tonight, you can watch this program on City Media TV on Facebook. You can obviously watch it on my profile, Thomas Berbel, on Facebook. You can also watch our channel, Citilaw Solicitors channel on YouTube. And most of all, you can listen to this program on City Media Radio. So you are covered on social media. You have all the channels to either watch or listen to this educative program. So I'm going to go for a short commercial break, and when I come back, I continue my discussion on the new divorce laws coming into force on the 6th of April 2022. Don't go away. viewers, thank you so much for your patience. As I said from the beginning, tonight is another opportunity for us to discuss law. We'll be looking at the family law tonight. And most importantly, we'll be looking at the new divorce laws that are coming into force from the 6th of April 2022. But before I do that, it's important to also give the background of the old law and why these new laws are quite significant. I'm sure that most of us are already familiar with the old law. Normally in the UK, if for whatever reason you've had problem with your spouse and the marriage has fallen on rocks and both parties want to go on their separate ways, then there is a ground which is unreasonable behavior, and people or couples were required to establish 5 facts. Now those 5 facts can sometimes be very problematic, and in most cases have led to the acrimonious ending of the relationship. So Parliament thought it wise that a new law should come into force to make that separation quite amicable, in a way to end the acrimonious ending of that marriage by parties establishing fault against each other. So in the past, people have to establish fault. So under the new law, there is going to be what we call no fault. But obviously, it's important to also look at these facts and why these facts were in a way to establish faults against the parties in the relationship or in the marriage. Now, as I've said, to prove that ground, you need to establish a fact. And the foremost fact is to establish that, for example, there has been an adultery, quite uncomfortable for the other party to admit that, in fact, he has committed that adultery in the relationship. And most times, the other party may contest it, and it exacerbates the acrimony, or it makes the relationship even more acrimonious towards the moribund stage of that marriage. The second fact people will have to establish is behavior, where one may say that the behavior of the other party is such that it would be unreasonable for them to live with that particular party in a marriage. So it could mean that they don't have a common interest in the marriage. It could mean that the other party is not financially committed to the relationship. It could mean that the other party perhaps spending more time outside the relationship. So that is establishing the behavior as a grounds for ending the marriage. The other fact to establish as a ground is separation of 2 years or more with consent, which means that one can reasonably argue that they have lived apart either within the same household, but they are living apart. There is no consummation of that loving relationship. And because they have lived apart, so living apart in the past not necessarily mean that you are living in two different households. You can live in the same house, but living apart. And if that subsists for 2 years or more, then with consent, the relationship with the marriage can be brought to an end. Again, it's establishing a fault, accusing the other of living apart. The other option or fact is 5 years separation, where one will say that the other party have lived apart continuously for 5 years, and therefore without consent they can bring that marriage to an end. Again, it's also establishing a fault against the other party. And the fifth fact is desertion, where one will say that he's been deserted by the other party, perhaps not being financially committed to that person in the relationship. So these 5 facts, either of these 5 facts or more, needs to be established in order to bring that relationship to an end or that marriage to an end. And obviously, these facts normally involve establishing a fault against one of the parties. And that is why most times it is hugely contested in the court, because the other person will be disputing those facts which have been alleged against him or her. If you are going to adultery as a ground, the other party can say that no, this never happened. If you are attacking the other person's behavior, the party, being the respondent, might say that no, this behavior never happened. If you're about separation, 2 years, the other party might say, no, I won't give consent because it's not true. If we're about separation for 5 years, the party will say that, no, it is not true. Last time we even had a party together. We were together, in the house, we rekindled our relationship. I remember one of the cases that we were doing, where the man was saying that he had a birthday party and the woman organized that birthday party. So in fact, they have not separated. So all these were issues that perhaps dragged the already acrimonious relationship that could have been brought to an end peacefully. So Parliament, in its own wisdom, passed this new law that I'm going to discuss, obviously, to bring an end of these faults that parties were meant to establish in order to bring a long-lasting relationship to an end. I am not by this encouraging people to end their relationship, please. So, when this old law was much of a problem to the parties by locking horns on the issues at stake in terms of contesting those grounds or those facts made against them, which sometimes were quite embarrassing for the parties. And therefore, this new law is intended to address these faults that parties were obliged to establish against each other. Imagine somebody you have lived with for years making accusations against you just to make his or her ground stronger to end the marriage. And how fuming the other party can become by knowing that this is what has been written against him or her in the family court. So these faults or facts to be established as a ground of divorce are going to be abolished under the new law. So having explained the background to the old law, now it's time for me to introduce to you the DDS, in short, which is Divorce, Dissolution, Separation Act 2020. Now, this legislation comes into force on the 6th of April 2022. Now, before I explain the changes that are going to take place from the 6th of April in terms of the detail of this legislation, it's prudent to also explain what is going to happen within the 31st of March and then this 6th of April. First thing for viewers to take note of is that for those of you who may want to do your applications on the portal, you have the opportunity from now. Some of you may have started your applications, save it on the portal. You have the opportunity from now up to the 31st of March, 4 p.m. to complete those applications. So all the facts that I have just explained to you are going to remain your ground for bringing to an end your marriage, for whatever reason it is that you want to bring that relationship to an end. So the portal is going to be available up to the 31st of March 2022. So within this window period, you are able to still continue these applications on the basis of these grounds or these facts that I've just explained to viewers. But something significant will happen from the 31st of March, 4 p.m. to the 6th of April. Nobody will be able to use that portal to make any application whatsoever under the divorce law. And then from the 6th of April, when this new law comes into force, you will not be able to rely on the old grounds or facts wherein you were required, obliged to establish a fault against an opposing party in order to bring a marriage to an end. So you have almost 6 days window when things will be in vacuum, where nothing can happen. So people have to take notice of this window period. But having said that, now is the time for me to talk about the DDSA, which is the Divorce, Dissolution, Separation Act 2020. This act has been passed, received royal assent, and is coming into force on the 6th of April. Let's look at what is going to happen from the 6th of April. If for whatever reason you now want to, or you have to, bring marriage to an end. All the stuff that I have just explained to viewers are no longer going to be binding on the parties who may want to bring their marriage or relationship to an end under the new law. In fact, the new law removes, if you look at the section 1, it removes the obligation on parties to establish facts. What are these facts? These facts are what I have just explained, namely desertion, separation of 2 years with consent, separation of 5 years without consent, adultery, and unreasonable behavior, or what they call behavior in a sense. So this new act removes all these facts, because I've already explained that establishing these facts means that parties were obliged to establish fault against the other party. And that is the reason why this new law is becoming obsolete, because it's intended to make ending this relationship amicable. I'm sure people will contest whether or not there is anything that ending relationship amicably. But of course, having practiced in the family law for some time, I know that there are some relationships that are ended amicably because people feel that they are better off going their separate ways sometimes than being with that person. And because of all the stress and emotional stress that comes with it. Therefore, sometimes they feel that going separately is more of peace than living in silence and acrimony. So obviously, this new law is intended to make ending of these relationships or marriages which are already on the rocks quite amicably. And therefore, the Divorce Dissolution Separation Act 2020, which comes into force on the 6th of April, removes those grounds or facts that I've just enumerated, 5 in total. So, to now explain the new law to viewers, the new law obviously detects that parties can still make these divorce applications, but these applications, rather than establishing faults or facts, they can now support it with statement. So a party can make, in the past, people will make application as petitioners. They will petition the other party. They petition the other party that party has conducted themselves unreasonably. That party has conducted adultery. That party has separated from them. So those facts needed to have been established in order for the court to have that discretion to proceed with that divorce. And the party who will be at the receiving end, normally his involvement as a respondent to the petition or to the divorce proceedings will be just consenting to or either signing the acknowledgement of service. And obviously, once the acknowledgement of service has been signed by that party, either disputing the grounds of the divorce, as I've just said, or consenting to that grounds, that perhaps might be the end of the respondent's involvement in the whole proceedings up to the stage of decree absolute being issued. But obviously, after the 6 weeks plus 1 day, and then within 3 months, if the petitioner have not applied for decree absolute, then of course, that respondent will be entitled to make an application. So you realize that from what I've explained, most cases the respondent doesn't play immense role in this whole proceedings. But under the new law, let's contrast it with the new law. The new law, as I've said, that parties don't have to establish faults. Rather, when they make this application, they have to support it with a statement. And that statement can come from one of the parties of the marriage. So it's mere making a statement of intention to end your marriage. Or, in these cases, because the law has that embodiment of making it peaceful and amicable, both parties can make that statement to the court and say that by these facts they have agreed to end their relationship. So rather than establishing a fact as a ground for divorce, people merely have to make statements under the new law. But when these statements are made, then the court has a discretion to give an order. And under the new law, that order remains conditional. And I'm going to take my time to explain what I mean by this conditional order under the new law. The reason being that when statements are made, in support of the application. So in this case, both parties can become applicants. Whilst under the old law, one party is a petitioner and the other party is the respondent to the proceedings of the divorce. Under the new law, both parties can become applicants, or one party can become applicant being the one engineering the process by supporting it with a statement of facts, why that relationship sadly must come to an end. But having said that, I've already explained that both parties can become applicants where they give a joint statement in support of that application. And that is the intention, to make it amicable. But whilst those statements are filed, then an order for divorce can be made. But that order remains conditional. And parties have 20 weeks. Because that 20 weeks is a window period for people perhaps to fall in love again. Oh, probably we made a mistake by making this statement to the court. We feel that our differences have now been resolved. Because in the past, people would have made the situation worse by establishing faults against a party, thereby making that party very, very angry. But now, because it can be done by joint statement or a statement without making any allegation against the other party, that ending of that relationship under the new law is purported to be peaceful. And I'm sure most of you will disagree with me. But the fact remains that that is the intention of Parliament by passing this law. And because of that intention, that is why Parliament is giving 20 weeks for people, after they have made this application and a conditional, an order for divorce has been made, that order remains conditional until a confirmation has been made by either of the parties. In this case, it could be the person that made the initial application, or any of the parties to the marriage making that confirmation to agree to end the marriage. So that 20 weeks is quite crucial. As I've said, it's a period where people can fall in love with each other. It's a period where people can resolve their differences. It's a period where people might feel that it's quite wrong for them to go their separate ways. Perhaps they are better together than going their separate ways. But the similarity of the old law and the new law is the fact that people still have this 6 weeks plus a day to apply for their decree absolute. So I want viewers to take notice of two things here. One is the 20 weeks for people to try to rekindle their relationship. But under the old law, normally after decree nisi has been granted, then the petitioner will have 6 weeks plus a day to apply for what they call decree absolute. Obviously, this decree absolute has immense effect on people's inheritance right. And recently, I was discussing some of this case with a family member when people, with respect, are so naive on some of these issues. And that's why we bring this program to you, so that people can understand this. Because people may not want to hear some of these things being discussed in public. And then they make horrendous mistakes, lose assets that perhaps they have built for years, because the biblical word says that lack of knowledge, my people perish. People must get this knowledge, because this knowledge will set most people free. Now, so that similarity still remains there, on the grounds that within 6 weeks plus a day, as I've said, that conditional order remains in place. But any of the parties can still apply by giving that confirmation and make that application for decree absolute. But in the past, what is the difference? People didn't have this 20 weeks window. So once you put in the application, you have 20 weeks to relax, to think. Sometimes people may want to just test the water. They want to put in. I had a friend whose spouse put in the application, and eventually he have to withdraw. People put in this application. Sometimes they have a change of mind, a change of heart in the course of time. And the law have studied all these behaviors and taken it into account. But because people may have change of heart, change of mind in the course of time, why doesn't the law give them 20 weeks to make formal decision on some of these crucial issues that affect not just the parties, only the two parties involved, but even children and assets that have been acquired in the course of the relationship? Now, if you have joined me tonight, just now, tonight I am discussing the family law and the new changes that are coming into place on the 6th of April 2022. And for those of you who have just joined me, I have looked at the old law, old divorce laws. I'm looking at the new divorce laws. And I'm looking at the fact that the intention is to make this whole process quite amicable, and also to make it easy for people to come back together. People coming back together because they have not accused each other, or they have not formulated lies against each other merely because they could have their way by ending their marriage. And that is why Parliament felt that the old law was not good enough, because it teared up the already tense relationship, the already acrimonious relationship. And the new law has the intention of bringing people together only when people within 20 weeks have decided that things can never work between the parties. That is the only time that they are obliged to give confirmation to officially end the relationship. But I've said that within the 6 weeks plus a day, so which means that right from the day they make the application with their supporting statement, they say have 20 weeks, including when they can even make the application for decree absolute within 6 weeks plus a day. So you will see that from what I have explained so far, it's only few things that have changed here. The only thing that have changed here, perhaps, are two things. The facts of establishing a fault against a party, and the fact that there is now an added advantage that people have 20 weeks to think of coming back together. And presumably making this whole thing quite peaceful and amicable rather than acrimonious. But having said this, obviously I said that this is making people, tonight's topic is about making people of the new law that is coming into force. But having discussed this new law, it's now significant to look at a new law or a new case law which clearly gives reasons or grounds for what they call decree absolute to set aside. And I'm sure that most people we've had contact with who have had these issues. I want to explain the case of R versus R, which is a new case law that came in about a month ago. And in that case, I'm going to explain why decree absolute can be set aside. Now, for those of you who may be confused with my legal terminologies, when I say decree absolute, I mean that when people have gone through the divorce proceedings and have issued decree absolute, which be confirmation or entitlement to divorce, and after 6 weeks plus a day, they have applied to make that decree nisi or that divorce absolute, which is officially bringing it to an end. But under the old law and still under the new law, this whole process should involve the two parties. As I've said, the respondent under the old law will have to acknowledge the service of the petition of divorce and respond to it. So both parties must have full knowledge of the divorce proceedings. So both parties under the new law and the old law could, obviously under the new law, you cannot challenge the fact that a fact established against you is unacceptable, so you don't want the divorce to go ahead. You cannot actually hijack it. It's a free fall. Once a statement of support has been made in support of the application, even if the other party disagrees, they cannot stop it. And I remember one of the cases that went all the way to the Supreme Court, where the man was contesting the grounds of the divorce. And the case dragged on all the way to the Supreme Court. And they had to wait up to 5 years, because under the 5 years, facts establishing 5 years as a behavior, obviously you don't need the consent of the other party. So people have to be mindful of this. Sometimes there have been cases where, for one reason or the other, a party might not find the other party, and they may still want to go ahead with their divorce because they feel that the other party is nowhere to be found. Now, under the new case law, which I'm going to explain for the benefit of viewers and for people to be cautioned whenever they have these problems, they have to seek proper legal advice. Now, this case, to be precise, is about a man who divorced the wife in 2010. Now, when that man decided to divorce the wife because he has found a new girlfriend, the wife was nowhere to be found. So what he did is that he established 2 addresses, and eventually he signed acknowledgement of service, and then eventually applied for decree absolute to bring the marriage officially to an end. So the case of R versus R established that if one is to divorce another person, then both parties must have full knowledge of the proceedings of the divorce. And this man went behind the woman, so without the knowledge of that particular party, signed the acknowledgement of service, and eventually the divorce went through. This happened in 2010. Now, it's only recently that the woman found out, when he wanted to go and put in her own divorce, he found out that he has already been divorced by the husband. So when she found out that she has already been divorced by the husband, it means that that divorce was done by what they call forgery. And what is the consequence of a divorce by forgery? Now, in the case of R versus R, the consequence of divorce by forgery means that that divorce was non-starter. It means that that divorce can be set aside. It means that that divorce never happened at all. For those of you who sometimes, one reason or the other, undertake this process, the danger is that in the case of R versus R, because that divorce was by forgery, and that forgery is just because of the fact that the other party, which is the ex-wife, didn't have knowledge of the divorce proceedings and did not sign the acknowledgement of service. It means that that divorce was by forgery. And therefore, the case of R versus R, the court set it aside. The implication of that is that every asset that has been acquired from that 2010, when this divorce was purported to have taken place, including the new wife that this man has married, that marriage was null and void. Which means that if, in fact, this man, looking at that case, has acquired a lot of assets and had case, perhaps even made a will. So the fact that that divorce was by forgery meant that there was no divorce at all, because that decree also was set aside. It means that everything that was acquired between 2010 to 2022, as we speak, that ex-wife has interest in it. And this whole process needs to commence in order to bring that marriage officially to an end. And I know that most of you watching me tonight might have experienced or must heard something like that. It's a warning, and that's why this is quite educative for every one of us. So if you want to go through divorce, my advice to you is that, now last week I was saying that look for a lawyer, a good lawyer that can help. If you cannot find your husband or your wife, and for whatever reason you want to still go through that divorce, or you've been deserted or separated and you can't find a whereabouts, I always say look for a lawyer, which is good to assist you. But MC Shaka says that I should not say look for a lawyer. I should say that come to Citilaw Solicitors, because we are family law accredited, and we will be able to assist you to make these applications. Because even under the new law, the other parties still have to receive service, and confirmation needs to be made. And look at the danger of you thinking that your marriage or your divorce or your marriage is over, your divorce is complete, and eventually becoming a millionaire, and suddenly somebody coming from nowhere and taking everything or half of it from you because of the fact that your divorce was done by forgery. And whenever I come to this platform, I educate the public, and whenever I am making references to issues, they are not fiction, they are facts. Because this is a case of R versus R, which is hugely contested case, well reported, that makes it clear that though this man assumed or purportedly divorced in 2010, that decree absolute was set aside. And therefore, everything that had been acquired in the course of that 10 years, when he thought he has divorced because of the fact that he didn't use the right procedure to go through that divorce, means that that divorce has been set aside, and therefore the whole process needs to commence again. So tonight is been privileged having you to explain the new laws that are coming into place, and also to educate you how to avoid divorce by forgery. So to give a summary of what I've obviously discuss tonight for the benefit of those of you who have perhaps just joined. Tonight I've been looking at the new divorce laws coming into force on the 6th of April 2022. And I have looked at the old law and the new law, which is yet to be enforced, which is 6th of April. I said that Parliament's intention is to bridge a gap, which is under the old law, there are 5 facts that a party needs to establish against the other party in order to bring marriage to an end, which is 1, behavior, where one may say that the other party doesn't have a common purpose with her or him, or the other party spends more time outside, forming new relationship outside, he or she feels isolated, and therefore it will be unreasonable for that person to continue to live in that marriage. That's one fact to establish as a ground. The other one is adultery, where one can accuse the other party that he has committed an adultery, and for that reason it will be unreasonable for him or her to continue to live with the party who has committed adultery. The second fact is separation for 2 years with consent, which means that the other party will say that even though we might be living in the same household, he has a different bed from me, we don't consummate, and the relationship is no longer loving. We live separate lives. So separate life doesn't mean that you live at 2 different addresses. You can live in the same house. But that divorce can only be ended with consent of the other party. And I was just giving an example where one of our clients, the woman was saying that they have separated. He said, no, we haven't separated. Last few months, you organized a birthday party for me. So we have not separated. And this case has been dragging on. The other fact is when there is separation for 5 years, you don't need consent of either of the parties under the old law. And finally, the 5th fact is when there is desertion, where one party feels that you've been deserted by the other party. So we can see that, looking at the old law, all these facts can only be established by establishing a fault against the other party, which in this case will be the respondent. So the petitioner needs to put in an application, petition the court that this either one or more of these facts have been established in my relationship, and therefore I'm seeking to bring it to an end. And the respondent in this case needs to acknowledge the service, which they call acknowledgement of service. But by the time parties have looked at what has been said about them, either adultery or any of these facts that I've just explained to you, then it makes the already tense relationship more acrimonious. So why the new law? The new law, by Parliament's intention, is to make bringing relationships to an end, namely divorce, quite amicable. And the reason being that under the Divorce Dissolution Separation Act 2020, which comes to force on the 6th of April, it removes the obligation for a party to establish fault or facts against the other party, which means that by mere making application and making statement as an applicant to the court will eventually bring the marriage to an end, which means that you have no duty, no obligation whatsoever to establish a fault against that party. And more importantly, 2 parties can make that statement as applicants. So we don't have what they call petitioner and the respondent. You can have the parties in the marriage, 2 of them being applicants, or 1 of them being applicant. Further, they have 20 weeks within which they can fall in love again, have a change of heart, have a change of mind, and come back together. So within that 20 weeks, they are not obliged to proceed with a divorce, so they can just leave it there and eventually come back together. So they have 20 weeks to give what they call confirmation of their statement that they actually intend to divorce. But the similarity within these two laws is the fact that people are still entitled after 6 weeks to also make application for decree absolute. So normally, when a statement is made by a party seeking divorce and the court makes an order, that order becomes what they call conditional order under the new law. And that conditional order remains until such time that either of the parties or both parties have submitted statement of confirmation that they actually intend to divorce. But all in all, they don't have the established fault against any of the parties in the marriage. And they also have 20 weeks to make up their mind on this issue. So this is the distinction between the old law and the new law, which is coming into force on the 6th of April. But I've said that on the portal or the process of making these applications, obviously parties who are yet to make this application, they have up to the 31st of March to make the application 4 p.m. And if they don't, within 31st of March, 4 p.m. to 6th of April, there wouldn't be any process on the portal for people to make these applications. But they said that after 6th of April, when the law have formally come into force, people can make this divorce application under the new law. So if you have joined me for tonight, this is what I've been discussing. And obviously, may I take opportunity to acknowledge those who have been watching tonight. I have, I'm sure I haven't looked at my phone for a while. I have highly favored Priscilla watching. I have Mary Entry watching tonight. I have Tega Opa Edward all the way in Abasa watching. I have Jack Hija watching. I have Hockey Tay is watching. I have Abena Jamfa watching. I have Guy Papa. Oh, Peter, how are you? I have Jackson Nose watching. I have Ernestina Kerikeri. Ernestina is always here. Thank you, Ernestina. Oh, Joe Chaka, welcome from France. I'm sure you had a good time there. I have Gloria Japan watching. I have Bernard Wafe Ano watching. And I have Riafo Frimpon. I have Ekins Kwao watching. And there's not Kerikeri is a good job. Juliet Dufour is watching. Akosua Agent Frimpon. Akosua Agent Frimpon. Former immigration officer, how are you doing? And I have Gifty Frimpon also watching. Now, it's been a privilege having all of you on this platform tonight. Here is where we teach the law, numerous areas of the law, because we know that people don't just have to be concerned about their immigration status, but after they have moved from there, they also need to understand the family law. Now, so I was just saying that if divorce is by forgery, which is, it doesn't mean that somebody has committed a very serious criminal offense. In fact, it's under the family law. But of course, if the party may want to take it further. So the new case, the case of R versus R. So for those of you who, for one reason or the other, may have gone through divorce without the full knowledge of the other party, that divorce can be set aside. It means that this can affect one's inheritance under will. It also means that that marriage was never came to an end. So both parties eventually may have to start this divorce again. And simply by conducting this divorce, where, for example, one person will have another address, the other person will have an address, and it's established that that party did not have the benefit of being involved in the divorce proceedings. And that's why I have given an advice that normally there are clients that come to us that they can't find their partners, their wife, their husband, they want to go through divorce. We have a procedure for doing these things. That's why we are lawyers. we engage private investigators, we go through all the process, and then show to the court that we have done everything reasonable to find this person, and therefore we are obliging the court to proceed with this divorce. So I'm not saying that if you can't find your husband or your wife, you cannot end your marriage if you have been deserted. But I'm saying that if you don't seek proper advice and do that divorce as people normally do, then under the case of R versus R, which is a very recent case, wherein that man conducted that divorce, he actually did the divorce, and the court said that when they sent letter to the address purported to be that of the wife, either he signed it or it was signed on his behalf. And in that case, they employed an expert to check whether that signature was that of the ex-wife. And the expert confirmed that the signature was never that of the ex-wife. It means that either the man signed the acknowledgement of service himself, or someone else signed it on his behalf. And because of that evidence being adduced to the court set that decree absolute aside by forgery. It means that that divorce was never a divorce. And obviously I've explained to viewers, that means that if you have a house, this woman may have a better interest in it. If you have made a will for your kids, this woman will have a benefit in it. And everything that you have acquired, this case that I'm talking about, this man did the divorce in 2010. So it's taken almost 12 years for this to come to light and for everything to be set aside eventually. And that's why I always say that when people have legal problems, they must see a lawyer who is able to advise them on the most safest remedy for them to deal with those problems. When I'm not well, I go to the doctor. Because I know that that doctor is qualified, well trained, and is able to give me the treatment that will give me peace of mind. Even though if you ever had that problem where you didn't have the peace of mind and you feel that there is clinical negligence, again, Citilaw Solicitors, we are here to chase those people to get some compensation for you. But obviously, most times, 99 or 98% of these people are qualified and therefore they can give you proper treatment. The same vein, even though MC Chaka says that I should not say that, go and look for a good lawyer, because Citilaw Solicitors, we are family law accredited. So we are here to assist you. If you ever had any of that problem, don't sit at home and do these things yourself, because they may come back to haunt you in the future. And if all of us may take some of these things for granted, until one day it will become known and then it becomes an issue. So please, tonight has been an opportunity for us to discuss the family law, specifically the new divorce law that is coming into place. But above all, making people aware that there is a procedure for them to follow so that these legal requirements are satisfied, without which they end up into numerous problems, as I've just explained in the case of R versus R. I'm sure this man perhaps didn't have a good advice. If he had come to Citilaw Solicitors, would have just advised him that, look, if you can't find this woman, this is what you have to do to say make your divorce legit. Somebody will say legit. So she didn't probably come to Citilaw Solicitors then. And that's why after 12 years, he now found himself into trouble. So these are some of the things that are happening around us. I want viewers to take note of it. Now, having said this, I'm going to take the opportunity to obviously give a little bit of advert about what Citilaw. I've been here speaking for a while now about what Citilaw Solicitors do and where you can find us in case you're looking for Citilaw Solicitors. Citilaw Solicitors is a firm with diverse, qualified solicitors, some accredited under the family law. So if you want to look for us, we are embarking. Obviously, we are very close to the Barking train station. If you get to the station, you just turn right, and then you just find Barking Enterprise Center, wherein you can find the Citilaw solicitors with their offices all over the place. And obviously, we specialize in immigration. I'm going to give a short update of the immigration law tonight before I leave here. We specialize in immigration. We specialize in employment law. Last week, I've noticed that about 4,000 people have watched this video. How people can have the benefit of flexible working under the employment law. This is what Citilaw Solicitors brings to you. For you to have that peace of mind, even at your workplace, if that employer seeks to dismiss you unfairly, we will go after him to get compensation for you. So if you ever had any problem with your employment law, either unfair dismissal, discrimination, settlement agreement, don't go far. We do most of these cases on conditional fee agreement, which means that if you win your case, we only get a token of whatever you are paid. If we don't win it, we, including myself, work in vain. So that's why there is no moral hazard, because we have a common interest to win this case, because we all benefit. If you don't win, we all lose. So don't go far. Come to Citilaw if you have your employment law problems. Family law, as I've just taken my time to educate the public on the new law that are coming into force, including those who perhaps may have issues with this divorce by forgery and the warning bell ringing in the case of R versus R. Obviously, I'm sure people are going to take note. But if you have a family law problem, if you have that difficulty seeing your child, you are entitled to make child arrangement order. If you have, obviously I'm sure pastors may disagree with me, but there are relationships that may eventually come to an end, and of course people need to secure their interests. So if you have any divorce problem and then you want a lawyer to help you to secure your interest in a matrimonial asset, Citilaw Solicitors, we are here to help you. If you are suffering domestic abuse, or somebody have made allegation, lies against you for domestic abuse, and you want a lawyer to defend you, we are here to support you under our family law. Personal injury and clinical negligence. For those of you who are having accidents at work, I always remind you that when you have that accident at the workplace, you are not just entitled to sick leave. Please, you are entitled to what they call personal injury claim compensation. Because some of you could be deformed for life. You may have disability as a result of that injury at the workplace. You have been on admission for 3 weeks. That is money. So if you ever had any problem at the workplace, accident at the workplace, don't go far. We do this case on conditional fee arrangement or agreement. If you win, we win together. If we lose together. We only get a token of the percentage of how much you've been paid as a result of our hard-fought case. So whenever you be involved in an accident at the workplace, you are in a car, you had an accident, any form for accident, you work on the pavement, local authority, not making things clear, public liability, we are here to assist you to get that compensation that you deserve, as long as that accident was not your fault. Also, if you ever went for a treatment with the NHS and you had a problem that you feel that have been multiplied, or there is clinical negligence, we will look into it and get you that compensation that you deserve. And housing disrepair. Some of you are living in houses, there are wires hanging all over the place, the doors are not well secured, the windows are not double brazier, damps all over the place, water leakage, cockroaches, mice infestation, you are entitled to a compensation from that landlord. And most cases, these landlords now have insurance cover. They will pay for the injury that they have caused to you. So please, if you ever have any housing disrepair problem, don't go far. Citilaw Solicitors, we are here to assist you to claim that compensation that you rightly deserve. And again, this is no win, no fee. If we don't win, we lose together. So we have a common interest. So I'm urging you that don't take these things for granted. They are money. And again, if the consumer law, if you have any problem, if you are somebody who sells stuff, you want us to draft terms and conditions for you so that when there is cancellation and all that, you don't lose money or people don't make unnecessary claims against you. Because you need to understand the Consumer Right Act. And don't allow businesses to take you for granted, because we have a right under the consumer law. So if you ever have any consumer law problem, Citilaw Solicitors, we are here to assist you. Somebody called me from Ghana today. He's made a movie, and he wants it to be protected so that she can continuously enjoy that royalty. She's putting a lot of money. It's an investment. So under our entertainment and media law, if you come and see us, we'll be here to draft some of these agreements for you. Protect your talent that God has given to you so that you can continuously benefit from it. Now we go deep into the law because obviously we know that there are a lot of people who are doing well in all these areas and they need to protect their investment, their talent. So if you ever have any of these stuff and you want us to help, we can help you. Of course, 6th of April, a lot of things are happening. Those children who have been here for 7 years, they are now entitled to, now I'm talking about immigration. They are now, in fact, I think that after we exited the EU, Home Office have been quite flexible in terms of the applications that are made under the immigration rules, apart from the fact that they have decided to tighten the EU settlement scheme application. But of course, we still are available to assist clients who are going through those challenges. But there has been a lot of good news. I know that about a month ago, I said here that previously, when people made applications as parents of British children or children who have been here for 7 years, and they were put on a 10-year route, those parents had the opportunity to switch to 5-year route, provided they did the English language test. But what we noticed is that whenever people, I remember I dealt with a client, she needed to remove the no recourse to public fund. So what happens is that normally when people remove the no recourse to, they make application for change of circumstance to remove the no recourse to public fund. Then they put them on a 10-year route, which was a punishment. So now that has been abolished. It means that you can still have recourse to public fund and still be on a 5-year route, which is very, very generous. And then on the 6th of April, the new change is that children who are born here and 7 years, they are going to be able to make application for indefinite leave to remain straight away. But this is my view. I'm sure a lot of people are jubilating. But obviously, normally, because of my economic background, I look at these things. That's why I always advertise that when you come to Citilaw Solicitors, you are not just coming for law. You are also coming for advice on things that are very, very practical. Now let me look at this new law coming into place where children born in this country who are 7 years old can then apply for indefinite leave to remain. And there are a lot of jubilations. But let me tell you what people should consider when they are making those applications. And I want you to please listen to me attentively. When a child is born here, and that child turns 10 years, that child is eligible to make application for registration to become a British. Let's look at how much that costs. Less than 1,500. If a child is 7 years and makes application under the Appendix FM or the private life rules, that child is entitled to what they call fee waiver. It saves that child 2,613 pounds. So if you made the application at the age of 7 under a fee waiver, and then you turn 10, you then make application to register to become British, where you now pay the naturalization fee, because obviously Home Office disagreed to make those applications free or to be entitled to a fee waiver. Now, the fee waiver is not available to those who make application for indefinite leave to remain. And recently, we have been making a lot of applications for fee waivers, and most of these clients that will make this application for fee waivers for them, they always become successful. In my view, Home Office feels that we are losing money, so let them make this application for indefinite leave to remain anyway, because when they make an application for indefinite leave to remain at the age of 7, because they are born here, they will still pay us more money when they register to become British. However, if they continue to make this application under private life, all of them know the secret that they can apply for fee waiver. So we are losing money. So in as much as it's good news that people can now apply for indefinite leave to remain at the age of 7 if they are born here, in my view, economically, parents are not going to get the immense benefit. But that's a matter for another day. So these are the updates under the immigration rules for tonight. And I'm very grateful for all of you who have joined me tonight and make this program such a laudable one. And don't forget, on Thursday, MC Chaka is going to be here for us to take our time to go through the tree language of the same topic that I've discussed tonight. So for those of you who want to join us on Thursday evening, 9 p.m. sharp, we'll be here to obviously discuss the program that I've had tonight in tree language. So it's been an opportunity for you to have me tonight to discuss the family law with you. And our disclaimer is that every advice Citilaw Solicitors gives on this platform is for guidance only. Therefore, if you want to rely on it to make any application, we advise that you seek your own legal advice. And you don't have a lawyer, we advise that you can Citilaw Solicitors to assist you. Thank you so much for watching us tonight. It's been a privilege to have you, and I'm so grateful for all of you who have joined us tonight to have such an extensive discussion under the family law. God bless you all. Thank you.